So what occurs when the courtroom is the final barricade between common citizens and the law enforcement officers who are expected to safeguard them? One of the judges in this story does not want to sign blank checks for any weak charges, half-cooked evidence, and careless police work. He is instead a staunch person of logic, fairness, and the Constitution. However, the deeper he digs his own grave, the more appalling the facts become, and the bewildered police, the conflicting stories, the arrests founded on mere guesses. And by the end, you'll wonder, were they criminals or are these victims of failed policing? Let's find out.
The case that brought it all out. It begins small, with an easygoing assault case which ought to have been simple. Police say that a man by the name Ricardo assaulted a person and injured him. However, when Judge Fletcher poses the officer a simple question, the location of pain, it all goes to crashes. The officer can't answer. No evidence, no complaint, no account of pain. The whole argument is based on a supposition and falls to pieces at a single stroke.
And then everything else that he's adding is not in that document.
To be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer,
That's not in that.
But the officer. Yeah, sorry, Mr. Pons, I'm just.
The affidavit and that she said she didn't feel pain.
I don't know. All I know
I'm
is
telling
that.
you. That's what I'm up here challenging. The PC on that one?
However, the absence of evidence is not the only thing that surprises the court. It is the gumption with which the officer claims the attack to have occurred, as though documenting it can substitute reality. The judge goes on the offensive. Who told you there was pain? Silence. No witness, no victim statement.
So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on her body causes pain. So according to the full DIMS, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full DIMS states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
A complaint not even on record. The case is dismissed at the spot by the judge. But this is the open loop. When cops are making charges without evidence, how many other individuals are being charged off nothing?
He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that connection.
You don't operate on hunches.
Right. And she's also stated that I was fighting him. So that could be because of her fighting.
I mean, here's the deal. Like, if I find no PC, right, they may just re-indict it them.
This firing is the seed of a new trend. The courtroom now starts to resemble less a place of justice and a dumping place of bad police work. This is just the start, though, since the one that follows is even more disheveled. It is not a fight with police. A woman is arrested just because she is standing close to them. And that which the judge discovers next makes him wonder how the officers are taught to cope with war, and whether the officers know anything of the law at all. Nosy but not guilty. When presence becomes a crime. The second example is the case of Yananisha Winbush, a woman that enters a situation between the police and another person. She is accused by the officers of interfering. However, all this changes when the judge peruses the evidence.
What was she doing wrong?
So it appears she wasn't the initial person causing the disturbance, but when they came to respond to the disturbance that they were called for, she intervened. And once they asked her to remove herself from the situation, she refused.
You didn't say, when you initially started saying about everything, you didn't say that she was the initial cause of the disturbance, that there was a call for a disturbance. They get out there and she, I guess,
So what it says is that they made contact with the individual that was causing the disturbance, and then the defendant approached asking
See,
the
right.
officers.
So she just comes up, starts being nosy, right?
Right.
And then she basically, I guess, is trying to leave, and then they start asking her for her information.
The policeman says that she was in his path. However, when the judge poses the question, did she physically stop you from doing your job? The answer is unsteady, wavering, self-defensive, and truth escapes. It was not that she was grabbing, pushing, blocking, resisting. She was there, perhaps on the lookout, perhaps feeling, perhaps speaking, but not meddling, as it were, with the law. The punch that the judge throws at the officer stops the whole room. Nosy is not a crime. The officer makes another attempt. She was making a noise, the judge answers. Interference is not making a noise, and the case fails as the first. However, this dismissal shows more than that an officer is not misinterpreting interference. They are pushing it to the extreme, to the point that whatever a person does can be considered a crime. This is harmful, as the interpretation can be too extensive to allow police to go willy-billy. This correction of the judge is protracted, almost surgical. He makes the officer understand that law enforcement does not concern emotions, frustrations, or egos. It has to do with literal hindrance, and none existed.
Probable cause.
I'll dismiss the case, Judge.
When you go up and you get into a pissing match with officers, who's gonna win? Who's gonna win? Every single time. If you go up and you mess with someone who has the power of arrest, you're going to lose every single time. Don't go. It's not hard. I found no probable cause in your case, ma'am. Just be careful, okay?
However, the courtroom has barely inhaled when the judge is presented with the most touching case of the day. The case of chaos, confusion, paramedics, and a mother in need of medical assistance that desperately needed it. And this time around, the camera is recording the much more disturbing. Police officers who do not appear to be as interested in compassion as they are in control. EMS chaos, panic versus crime by officers. In the third instance, the courtroom is viewing body cam footage of a wrenching scene. A mother collapses, paramedics come in, family members panic, but officers add to the chaos rather than suppressing them. They identify a man, Waway Kemp, and accuse him of meddling with EMS. The video depicts otherwise.
Is he really trying to prevent an EMS person from doing their job?
So you look at the
Alex?
totality of the facts, it's like, how are you supposed to, how is he trying to prevent someone from doing their job when all he's trying to do is make sure that he's helping his mother, who they said, hey, we're not going to come to the house to even bring you in.
Does he pull the arm off?
According to the officer, he just grabbed it, and the officer grabbed him at that point. So the reason why, it's not really clear how quick it happened. On the video, it looks pretty quick because the officers grabbed him immediately.
Kemp is emotional, pacing, shouting, yet he is not coming into physical contact with the medics. He isn't blocking them. He is not avoiding treatment. He is a scared family member who is watching one of his loved ones struggle to survive. The judge scrutinizes each and every second of the video and poses a question that is critical. Who did he physically stop?
The defendant should have been aware of a substantial and unjustifiable risk of harm. Is there substantial and unjustifiable risk of harm in this case?
One moment, Your Honor.
The risk must be so significant that it's a gross deviation from what a reasonable person would do.
The answer, again, is no one. The officers claimed that they were feeling like he was dangerous. Nevertheless, emotions do not testify. The law calls for real obstruction. The judge's tone grows firmer. He describes the fact that during medical emergencies, there are high emotions. Panic is not interference. Fear is not interference. The desperation is not to interfere. The officers did not know how to differentiate grief and criminal behavior. When the judge throws out the case, one unpleasant trend is made apparent. Policemen are making arrests based on emotional catastrophe, not criminal offenses.
Even we looked at it, we don't see that.
Okay, I'm gonna find no problem.
Yes, yes.
And in case judges did not protest against this, then innocent citizens would have a criminal record just because they are human beings. But the judge has not yet come to the central issue of the problem. At this point, he starts to attack the source of the problem, which is not the citizens, but the police department itself.
Oh, come on. They charge him with theft because he's trying to charge his phone.
No, they didn't charge him with that, Your Honor. This is the.
I know, but that's the contact to get to him. All right, come on up. Hi, Alan. Tell me, what's up?
If we could get PC for Samuel Duto.
Shh. Okay,
I wanted to see if we could get PC for Samuel Duto.
okay, sure. You re-
Here on September 13th.
Okay, hold on. Just way too loud. Okay, so is he in custody?
Yes, he's currently in custody.
So he's got two cases. He got the theft and the failure to ID.
Yes.
Which one are you challenging?
Failure to ID.
Okay.
On September 13th, 2023, at approximately 3:22 in the morning, officers were conducting routine patrol at 7-Eleven. And the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out. They noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and identified and asked for his identification. The suspected charge is theft of a service under Penal Code.
Oh, come on. They charge him with theft because he's trying to charge his phone.
The judge draws a line. This is not the way the law works. The judge is able to see enough by the fourth case. The spirit of the courtroom changes. The officers are not only giving weak evidence anymore, but they are basing on assumptions, exaggerations, and their own frustrations. And the judge at length calls it out.
Be careful when you charge your phone. You now know they're going to mess with you anytime, even going to a 7-Eleven. You know what I mean? Be careful, right?
He clarifies in an easy yet convincing manner that the terms of interference, assault, obstruction, and resisting have got very strict definitions in law enforcement. The definitions are aimed at safeguarding both the officers and the citizens. However, when police officers consider anything that is inconvenient a crime, it becomes the failure of the justice system. The judge now becomes a teacher at this point. He dissects the law word by word and makes the officers face some gaps in their knowledge. Annoying is not illegal. Emotion is not obstruction. The painless contact is not an assault. It is not interference with presence. Officers attempt to defend their arguments, but all arguments break down in court. It is made evident that a good number of these arrests did not constitute justice, but a form of control.
I believe we're going on the failure to ID and dismissing the...
Dismiss the theft?
Yes, Your Honor.
Okay, that is a fantastic deal, Mr. Duato. I hope that you understand this and appreciate it. You know, most times people plead to the theft case and it really hoses them, because then you're looking at, you know, not federal, but felony time next time. So you're charged with failure to ID. It's up to a year in jail and or a $4,000 fine. They've offered you time served, 18 days in jail, credit for the 6 days that you've done. You're giving up a lot of rights by entering the disagreement, and same goes with you, Mr. Rivera. You both give up a lot of rights by entering the disagreements. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. Now, Mr. Rivera, you're charged with assault of a family member. You need to understand that this comes with an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases, you'll be facing a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? Have you ever been to prison before? It's not a fun place, man. You can never own a gun or ammunition as a result of this plea bargain agreement as well. You picking up a gun is a Class A misdemeanor in and of itself, okay? Okay, it says 21 days in jail, credit for the 7 days that you've already done. How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty, sir. And Mr. Rivera, how do you plead? I will find you guilty as well. I will roll both of your core costs so you won't owe anything, and good luck to you guys.
The power imbalance is being corrected in real time in the courtroom. The judge's message is simple. The power of the police is not infinite. It should be evidence-based rather than assumption-based. And then he issues a warning that as long as false charges are made, the court will no longer put up with it. It is not merely the dismissal of cases, but a cultural change that has to be imposed. However, the judge has one more strong word to say before the day ends, one that all officers in the room must listen to. Guarding the citizens against the system itself. It is not the last message of the day to the defendants. It directly targets the officers. The judge justifies that all false accusations, all overdone charges, damage the trust of people, and without trust, policing cannot be possible. He informs them the reality no other has told them. The decisions made by the police are not rubber-stamped in a courtroom. It is a protection to the citizens. In case the police present faulty cases, the judge will be expected to halt them, not to disgrace officers, but to guard the innocent. The Constitution demands it.
Or anything, so just be careful, okay? But I found no probable cause they're going to dismiss your case, okay? Just be careful in the future, all right, man? Okay, please. Good luck, okay, Ms. Wimbush?
He reminds them that citizens receive rights even when emotional, even when screaming, even when displeased. Authorities never simply vanish because an officer is challenged. The officers gradually start to realize this judge isn't their enemy. He is fixing them up before the streets fix them worse, by protests, outrage, and popular indignation. The judge concludes with a sentence which sums up his whole philosophy. The policing should be lawful, as freedom relies on it. And that is the end of the courtroom session. No punitive measures, but a reboot to remember that justice is not one-sided. A warning that the system should guard people, not only against the criminals, but the system itself, when it oversteps its bounds. But with the drop of the gavel, one asks, will the officers take the lesson of this? Will the judge have to repeat these lessons again? This wasn't just a day in court. It was an art lesson in fairness. The lesson of one man defending common men against the sins of the police, incomprehensible legislation, and hysterical responses. Small cases alone, but adding up to a collection of them, show that it is a system that can be easily abused by anyone, unless somebody takes a stand. Judge Fletcher was reminding them that accountability to power is tyranny. And it is the reason why voices like his count. In a world where a large population of people fear the law system, it gives hope that with the help of a judge defending citizens, this is possible. It demonstrates that there is still fairness, provided a person is bold enough to insist on it. You can get more of this reality-based, eye-opening stories by ensuring that you click that subscribe button. And believe me, you will not regret the next episode.